Well, in the wake of the legal challenge with the Rivers State government, the Federal Inland Revenue Service is reported to have written the National Assembly. They're asking for the inclusion of VAT collection in the exclusive legislative list. The Federal Tax Agency is also requesting the federal lawmakers to approve the establishment of the Federal Revenue Court in Nigeria. The Revenue Agency wants the legislature to vest it with exclusive powers on all adjudications relating to tax disputes, including federal tax laws, companies' income tax, petroleum tax, income tax, capital gains tax, stamp duty, VAT, taxes, levies, and other laws, regulations, proclamations, and government notices.
All right, let's now bring in Barrister Frank Tietie, the Executive Director of Citizens Advocacy for Social and Economic Rights, to discuss these issues. Thank you so much for joining us on Newsnight.
Thank you. Always my pleasure.
Yeah, before we come to the question of the constitutionality or otherwise of what the FIRS is saying that it has the backing of the VAT or VAT Act to collect this particular tax. What do you make of this letter to the National Assembly to, among other things, include the VAT in the exclusive lists and take it away from the concurrent
Well, thank
list?
you very much.
Yeah.
That letter weighs heavily against the Federal Inland Revenue as a defendant in the case that was instituted by the Rivers State government. The Rivers State government in that case brought out the letter in the middle of that case, saying that you can imagine that the Federal Inland Revenue had already acknowledged that it didn't have any legal basis for the collection of VAT, that is VAT, and then other taxes, withholding tax and
Income tax.
Withholding tax, and then education tax and technology tax. These are taxes that are not expressly mentioned as taxes collectible by the federal government. So the Federal Inland Revenue, in that case, it made it bare, and that's why it lost. If you read the judgment, the court was acknowledged that these are straightforward issues, and they didn't need to belabor themselves with a whole lot of facts, and that clearly the Constitution, the intention of the Constitution was so too manifest to the extent that they didn't even need to contend, and that's why they lost. Unfortunately, they were coming late because there were a lot of issues with regards to these taxes being already considered illegally collected by the federal government. There were a lot of cases in Lagos State, in Akwa Ibom, and even before the one in Rivers State. So the Federal Inland Revenue saw it coming, and they needed to have some form of political resolution of the matter. But it is actually deeper than that. We're talking about the foundational law of the country and the intention of the law as to allowing states to collecting some of those taxes.
All right. Frank, one wonder, since 1993, this issue has never come to the front burner.
Yeah,
Why now? But the Rivers State government insists that the FG should not collect that. The FIRS says status quo shall be maintained until the court processes are exhausted, and that by the VAT Act, they are constitutionally empowered to collect.
What are we talking about? You're mentioning an act as against the Constitution. Section 1 of the Constitution states it clearly that the Constitution of the Federal Republic of Nigeria is supreme, and it binds all authority and persons, including the federal, state, and local governments and all agencies of government, whether at the federal or state level. And it says that any other law that is made by the National Assembly or State Houses of Assembly that is inconsistent with the Constitution shall remain void to the extent of that inconsistency. So why are we talking about VAT Act when the Federal Inland Revenue had an ample opportunity to convert its case before the Federal High Court in Port Harcourt? It didn't. They didn't even mention the VAT Act. What they were kept on mentioning was the Taxes and Levies Approved List Act, which was a law. I'm surprised that the Federal High Court in Port Harcourt even had the understanding that an appeal court sitting in Akwa Ibom State had already declared that law, which gave the federal government the right to collect all of these taxes, including VAT, before now, because we were wondering why the status quo had been that the federal government was collecting taxes that it didn't have the legal right to collect under the Constitution, and there was nobody challenging it. The reason is that there was a military law. Wherever it is, we have savings provisions in our constitution that laws that were made by the federal military government actually were incorporated as laws of the Federal Republic of Nigeria. And there were laws that were made under the military that actually just, sweepingly gave the federal government the right to collect taxes that they didn't collect before. But we had a constitution, particularly the first schedule of the constitution, declaring the part 1 and the part 2 and first schedule of the constitution, declaring under its exclusive powers that at item 58 and 59, specifically saying that federal government, you can only collect stamp duty, and you can collect taxes on income, capital gains, and all of that, but strictly, that is, you can collect capital gains, incomes, and you cannot collect taxes to beyond the taxes that are listed in that in those items 58 and 59. So the judge was very clear and unmistaken about that, and he said this is the position of the law.
Well, I wonder how exactly this can be resolved. Is the FRS boss begging the question when he says that the VAT administration can only be handled at the national level? That, as a matter of fact, it is servicing the federation and not the federal government. Help us understand what he's playing out there.
I think
when you consider also, very quickly, so I can add this, that 2.4 trillion is what FRS is likely to lose. Doesn't it paint a picture of how much exactly the states are losing on a regular
exactly
basis?
With states, before I would like to deal with the first part of the question. The truth about it is that the FRS boss is treading on very dangerous grounds when he attempts to constitute himself into a superior court to the Federal High Court. Federal High Court has made the declaration. That's the position of the law. The Federal High Court has also refused an application by the Federal Inland Revenue, that's the first defendant, to stay the execution of that judgment. In fact, that judgment cannot, the execution of whatever, there's nothing to be stayed. That's the position of the law. So he cannot now constitute himself into giving directives and, giving imaginations of his interpretations of what the laws are. The status quo as we have now is that there is a substantive law in Rivers State. Rivers State is entitled by law and constitutionally to that extent to collect VAT. And that is the position of, unfortunately, some people may not like it, some used to benefit from it. But now, the second part of your question, whether the states are, that gave an impression.
Let me just ask you to hold on a little bit here. We have a sort from the governor of Ekiti State, Fayemi. Let's get to listen to what he had to say, and we'll come back to you, Frank.
Well, I haven't quite reviewed that judgment comprehensively. I've seen snippets of it. My colleague, the governor of Rivers State, has sent me a copy and sent a copy to our secretariat, and we've put it on the agenda of the Governors Forum and asked our Attorney General to review it so that we know the full implication of that particular decision at the Federal High Court in Port Harcourt, and then decide how to take it forward. If, as you say, it's going to be in the ultimate best interest of all states, then we have to look at it from that angle and take the position as a forum. But it may also mean, I haven't read it, as I said, comprehensively, it may also mean that the major beneficiaries of this will be the states that have been put in a position to generate VAT.
Governor Fayemi of Ekiti State, just very briefly, what do you make of what he said, and whether Wike has the right, because he threatened some companies and said that FRS was bullying. Does he have the right to do that? Quickly, very quickly.
No, but he's threatening to seal off Federal Inland Revenue Office. I wonder whether he has the powers, because he doesn't control the police, because it requires police to some extent to apply such kind of force. But plainly, we should be a country that aspires to be governed by law. The courts have said the Rivers State government should collect VAT, and so be it. The Federal Inland Revenue should not aspire to constitute itself into a court and to defy what the court has already said. They can go to the appellate court, they can go to the Supreme Court, but I think we are witnessing the prevalence of law. People, instead of fighting for all sort of resource control and turning the whole place upside down,
Frank,
approach the courts,
and
then we can find
we'll
some
see whether it goes, because I think it's going to go further. But let's watch and see.
Right.
Thank you very much,
you.
Frank Tietie there.